Hello, I'm Claire Babcock, an accredited claims agent at CCK Law.
And I'm Maura Black, a partner here at CCK.
There has been plenty of buzz about potential changes to VA this year, so we thought we'd examine a few recent developments that people might have overlooked, specifically as it pertains to VA appeals.
Yes, and one that our team who practices before the U.S. Court of Appeals for Veterans Claims, they've been paying very close attention to the layoffs at VA's Office of General Counsel. CCK Law does a lot of work with complex VA claims, including TDIU and special monthly compensation cases. And these and other cases can sometimes require appealing to the U.S. Court of Appeals for Veterans Claims, or the CAVC, where VA is represented by the attorneys within the Office of General Counsel. The OGC is relatively small, so layoffs there could impact the speed of appeals and appellants' wait times at the court. We haven't yet seen any definitive causes for alarm, and there are a number of lawsuits and proposed pieces of legislation that could change the scope of any VA layoffs in the future. But still, it's important and imperative for us to be as prepared as we can be. And that's why our firm has a lot of people working on tweaking our strategies based on whatever new developments we hear. And we'll be sure to keep you all updated and our clients updated on this as well.
Yes, another potentially big development that our agency team has been keeping an eye on is the regulatory freeze. In January 2025, the federal government paused all regulatory changes, which meant no rule changes could be proposed or issued. And VA has a number of regulatory changes waiting to be implemented, such as revisions to the rating schedules for conditions like sleep apnea, tinnitus, or mental health disabilities. This regulatory freeze is supposed to end soon, which means that all of these rule changes can finally take effect.
Right. Or maybe not.
Right.
We only say that because VA has been holding on to some of these proposed changes to its regulations for years. So because of that, we're never really quite sure when the rule changes will be implemented.
Very true. And we plan to do more blogs and videos walking through the rule changes once they finally launch. So we will be sure to keep you informed and stay tuned.
And now I thought we could pivot to a couple of key court cases too, because those fall within the realm of updates from VA that we have. So with all the talk around layoffs and benefits, there have been some recent big court decisions that might be overlooked. The first is in a case called Bufkin versus Collins. And there, the U.S. Supreme Court decided that the application of the benefit of the doubt rule in veterans' disability claims is a factual issue requiring clear error review by appellate courts. So, to try to explain that a little more, sometimes the evidence in a veteran's claim or case seems equally balanced for and against them. And in cases like that, where the evidence is approximately in equipoise, the Department of Veterans Affairs has a legal duty to decide in the veteran's favor. That duty is called the benefit of the doubt rule. And it's a pretty big advantage for veterans as far as the standard of proof goes and the burden of proof that they need to meet in their claims. But what happens if VA says that the evidence is not a 50-50 split and thus the benefit of the doubt rule doesn't apply? The question in Bufkin was, can the veteran ask an appellate court to reconsider evidence to see if VA got it wrong? And the Supreme Court said that no, an appellate court can't make its own new, fresh determination of the evidence. VA gets to decide whether the benefit of the doubt rule applies, kind of in the first instance.
Another big case was Chisholm versus Collins, which was argued before the Court of Appeals for Veterans Claims.
Yes. And in case you're wondering, the Chisholm in this case was our very own founding partner, Robert Chisholm. But that's not the only reason why we're bringing up this case. A lot of observers of VA law are saying that this could be one of the most important VA cases ever. So Claire, tell us more about why that might be.
Yeah, we'll be doing a separate video and blog on the Chisholm case soon with more detail, but we'll give you the gist now. VA has been attempting to be more and more strict about which forms a veteran must use during claims and appeals, and this can lead to a lot of bad outcomes for veterans due to minor technicalities. This form rigidity hit a new high after VA implemented the Appeals Modernization Act about 6 years ago. In the Chisholm case, the CAVC sent a clear signal that there are limits to how strict VA can be with forms. This can potentially affect hundreds of thousands of past and future VA claims, So this is a very big deal and I think a win for veterans. So please look for more information in the weeks ahead.
100%. We talk all the time about the importance of using VA forms. So this holding in the Chisholm case is really important for us and for the work that we do and to eliminate some of the procedural barriers that veterans face every day who are trying to get their claims and appeals before an adjudicator. So while there are a lot of changes and developments being discussed around veterans benefits right now, we do encourage everyone to keep an eye on the facts, rely on resources like your VA-accredited advocates, and stay as informed as you can without getting overwhelmed with everything. That's kind of why we're here. We wanted to provide this information in a distilled way. So we hope you found this helpful. Don't forget to like and subscribe to our channel if you think that this was helpful and you'd like to see more updates like this in the future. Take care.